Good morning. Welcome to another section of ICAN Online Tutors lectures. My name is Afiz Adebimpe. I'm a lecturer for business law. Our learning objectives. At the end of this study session, students should be able to define the term agency. Students should be able to explain the creation of agency. Students should be able to explain the circumstances under which an agent can delegate his authority. And also, students should be able to answer questions on agency from ICAN past questions. So we are going to look at all of this during the course of this lecture. What is agency? How can we define the term agency? What is the doctrine under which agency is based? There's a maxim called qui facit per alium facit per se, which means he who does an act to another is deemed in law to do it himself. That is to say, he who acts by another acts by himself. So an agent is an intermediary between party A and party B. An intermediary in this case is referred to as middleman. Let me create a scenario. ICAN Online Tutors is a business name. Afiz Adebimpe is an individual. Our students, they are the third party. I'm standing on behalf of ICAN Online Tutors to teach you. It invariably means ICAN Online Tutors is teaching you itself. So what we are saying in essence is that I'm only standing as a link person between ICAN Online Tutors and the students. That is the position of the law. An agent is somebody that acts on behalf of another. So should there be a liability, should there be a consequence arising from that action, the agent will not be liable, but the principal will be liable. So what agency relationship is explaining is the contractual agreement that exists between one party, known as the principal, who employs the service of another party, known as agent, to bring him into a contractual relationship with the third party. So the function of an agent is to bring the principal into a contract with the third party. Once that is done, the agent will back out, while the principal and the third party will link up to do whatever they want to do. An agency relationship is the fiduciary relationship which results from the manifestation of consent by one person to another that the other person shall act in his behalf and is subject to his control, and consents by the other so to act. So what I've explained earlier is that an agent stands as a link between the principal and the third party. An agent works on the authority of the principal. An agent cannot act on its own. Where an agent acts on its own, there is a consequence under the law. When we get to the effect of agency relationship, there I will explain that in further. Who is a principal? A principal is the one that has the authority. A principal is the one that agrees to expressly or by implication appoint another to act on his behalf. Who will the principal appoint? The principal will appoint the agent. The agent is the person who acts on behalf of his principal. And in law, whatever the agent enters binds on the principal. Authority. In this context, how do we explain authority? The authority of an agent is the act which permits or authorizes the agent to act based on the words of his principal. So what we are saying in essence is that the principal gives authority to the agent. The action of the agent is legally binding on the principal. So whether expressly or impliedly, in as much as the agent is acting on behalf of the principal is bound in law for any consequences that arise from that action. We are going to look at cases, scenarios where the action of the agent is binding on the principal, scenario where the action of the agent is not binding on the principal. When we get there, we shall look at it in details. Now, capacity. Remember, under law of contract, capacity is another element to a validation of a contract. For a contract to be valid, the parties to contract must have capacity to contract. So in this context, how do we define capacity to contract? Capacity to contract is the ability to enter into a contract to enjoy the benefit therein and incur any losses or obligation therein. Now, who must have capacity to contract? Who must be capable to contract? The principal in law must be capable to contract. The agent might not necessarily be capable to contract. For instance, the agent might be somebody below the age of 21 years old, but the principal must be age and above. Now, in this instance, when the agent is not capable to contract, can that agent still enter into a contract and that contract will be valid? The answer is yes, because once the principal is capable to contract, the agent automatically is capable to that contract. Any person can validly be an agent, even though they cannot validly act on their own behalf. What we are saying in essence is that in as much as the agent, the principal is capable, the agent is automatically capable, even though the agent in his own self cannot enter into a contract. Creation of agency. Creation of agency explains the ways and manner with which an agency can come to existence. So in your exam, examiner might ask you, identify 3 bases with which an agency agreement can come to existence. What they expect from you is to talk about creation of agency. In practice, agency relationship is created in a situation where the agent, by authority of the principal, is in capacity to enter into a contractual relationship with the third party, thereby made the principal binding on the contract. I've explained this earlier. Whatever action the agent entered into, the principal is deemed to be binding by it. Agency relationship or agency contract can be created in any of the following ways. 1, express appointment. From the term express appointment, it means that person is appointed by the principal, either in written or in spoken words. That's what we refer to as what? Express appointment. An agent may be appointed either verbally or in writing. There is no particular form of express appointment of an agent, but it may be by deed or in writing or even by the word of mouth. So what we are saying in essence is that in as much that that person is expressly appointed, agency transaction has been created. So whether there's a letter to that effect or whether it's by the word of the mouth, in as much the appointment has occurred, then agency relationship can be said to have been created. Implied agency is another way of creating an agency. So by implied agency, here, there is no express appointment, but agency is said to have been created based on the conduct of the parties involved. That is, an implied agency is an agency created by inference. For instance, automatically I'm an agent of ICAN Online Tutors. Why? Because I'm a tutor and I represent ICAN Online Tutors. So that makes me an implied agent. For example, in a partnership firm, a partner entering into a contract on behalf of the firm is assumed to be acting as agent on behalf of other partners. An implied agency may be either by necessity or by estoppel. I will explain that when we get to that level. So there's what we call agency by estoppel, there's what we call agency by necessity. Both falls under the category of what? Implied agency. But for example, you can actually break them down as types of creation of agency contract. Agency by necessity. In an emergency situation, agency by necessity may arise based on conduct of another person who acts in good faith to prevent loss to another person. If that occurs, we call it agency by necessity. But people can take advantage of that to extort another person. Then certain conditions must be met for us to say, yes, agency by necessity has been established. By definition, agency by necessity is that kind of agency that arises in emergency situation when one person is obliged to act to prevent irreplaceable loss to another person. An agency of necessity can be implied where the following conditions exist. I just mentioned earlier, if no condition exists, people can take advantage of that. So the law identified 3 major conditions, and all the 3 must exist for us to say agency of necessity has been established. 1, that it is impossible or impracticable to communicate with the owner of the goods in order to get his instruction. What we are saying is that for you to act as an agent in an emergency situation, for agency of necessity to have been created, there is impossibility and it is impracticable to communicate with the owner of the goods in order to get his instruction to carry out an action. Number 2, that there is an emergency situation or imminent commercial necessity to do so. Lastly, that you as an agent have acted in good faith and in the best interest of the principal. These 3 conditions must be present for us to say agency of necessity has been established. Number 1, that it is impossible or impracticable to communicate with the owner of the goods to get his instruction, that there is an emergency situation that brings about importance for you to carry out that action. Lastly, you as an agent, that the agent must have acted in good faith and in the best interest of the principal. These 3 major conditions must be present for us to say, yes, an agency of necessity has been created. Number 4, creation of agency is agency by estoppel. Agency by estoppel, in another context or in another books, you will see it to be called agency by conduct. Yes, even in most cases, it is being explained as an implied creation of agency. So you need to understand the context before you give response to your questions. Agency by estoppel. In a simple term, when somebody is acting as your agent and you do not stop that person from acting as your agent, the law will prevent you from denying the existence of that person as your agent in the event of liabilities. So what we are saying in essence is this: somebody is relying on your authority. Somebody is parading himself as your agent. He entered into a transaction as your agent. You did not talk. You did not stop him from doing so. Any liabilities incurred by that person in that contract will be borne by you. That is what we call agency by estoppel. The law will stop you. The law will stop you from denying the existence of that agency. By definition, agency by estoppel simply refers to a situation where somebody is acting as the agent to the principal, and the principal accept that conduct and did not stop him to stop portraying himself as his agent. In the event of liability, the principal will be liable. That is, the principal will be stopped or will be prevented from denying the existence of that agency. So I'm parading myself as an agent of ICAN Online Tutor, and ICAN Online Tutor is silent about it. They didn't tell the world that we don't know this man, no, is on his own. No. They acted as if I'm actually their member. So should I enter into a problem, ICAN Online Tutor will be penalized for that act. They will take responsibility of my misfortune. Agency by ratification. Well, by default, this is not a specialized type of agency creation, but where an agent carries out an act with or without authority and the principal ratifies it, then agency by ratification has been established. So what I'm saying in essence is that as an agent, I discharge a function, but my principal did not give me authority to do so, or the principal gave me authority to do so, but I did it in excess. If the principal thereafter approved my act, such agency created is called agency by ratification. So by implication, what do we call ratification? Ratification is the affirmation by the principal of an act done by a person who, as at the time of the act, had not been appointed to act so. For there to be an agency relationship by ratification, certain conditions must be fulfilled. We have about 5 conditions under this that must be fulfilled. Number 1, the agent at the time of making the contract must be acting on behalf of the principal or soon principal. So what we are saying is that at the time of acting as an agent, he must identify that somebody is there as his principal that is acting on behalf of someone. Number 2, the principal must have been in existence and have capacity at the time of the agent is acting on his behalf. So what do we mean? The first one, that the agent, when making the transaction, he must identify his principal, that the principal at the time of the contract must have capacity to contract. The principal must be competent at both the date of contract and at the date of ratification. The principal must have full knowledge of all material facts at the time of ratification. The contract that the principal wants to ratify must be a valid contract. It must not be a contract that is what? Must not be a contract that is void. That is, it must be a legal contract. Now, when validating a contract, time is an essence. When validating a contract, time is an essence. It must be done within what? Reasonable time. So let me take it in some way. The first one, for an agency by ratification to exist, certain conditions must be met. At the time of entering into that contract, the principal have capability to act. Number 1. Number 2, that the agent at the time of making into the contract must have stated that is acting on behalf of the principal. Number 3, the principal must be competent to act at both date of contract and the date of ratification. Very important. The principal must have full knowledge of the material fact in that contract before ratification can take place. The contract must be a valid one and not that one that is void, ab initio. time is an essence when we talk about ratification of contracts. Now, remember I was saying something earlier that an agent might act, and at the same time, his action will not be binding on the principal. We are going to appreciate that under effect of contract made by an agent. Contract made by an agent have different legal consequences depending on whether the third party had knowledge that it was entering into a contract with a named principal or not, or whether the principal was disclosed by the agent at the time of the contract or not. So all these are major factors that we need to identify when we are looking at the effect of a contract under agency. So effect of a contract under agency explains that who should be liable. Is it the agent that should be liable? Is it the principal that should be liable? So we need to understand this. I could remember there was a particular diet. ICAN asked the question, identify effect of agency relationship. So what they expect from you is to just explain these 3 terms. You don't need to cite cases. So to make business law very simple, it's always good to just do less of case. So when you are identifying cases, let it be simple cases that a student can relate with. So that is why I always avoid using complex cases that you find it very hard to understand. We are going to look at scenarios in this effect of contract, but what matters is you need to understand the terms one after the other to be able to identify who is to be liable, who is not to be liable. The effect of contract entered into by an agent with third party may be classified under 3 headings as follows. We have named principal, we have unnamed principal, and we have undisclosed principal. So on each of every term, we have its consequences. For named principal, when an agent contracts on behalf of a named principal, it is the principal alone who acquires the rights and liabilities under the contract. The agent incurs neither right nor liability. So in as much that the agent have identified that he's acting on behalf of so principal, he named this principal, it is the principal that will be liable. In this case, should there be a consequence action for my discharge, it is ICAN online tutors that will be liable because I'm acting as an agent to ICAN online tutors. That's a very good example to give you under named principal. Unnamed principal is a little bit close with named principal, but let's see what it means. Unnamed principal, where an agent acts for an unnamed principal, and provided he acts within the scope of his authority, only the principal acquires rights and liabilities under the contract. So like I said, it's so close to named principal, right? So for an unnamed principal, the agent is acting, but did not talk about the principal. That is, he did not name his principal. He's acting why, but he did not name his principal. Now, provided that he acts within the jurisdiction of his authority, within his scope of authority, the principal acquires all rights and obligations under the law. So how do you identify this in an examination? Pardon. How do you identify this? So the question will come like this. In that question, you need to read it well because sometimes it will look as if it is an undisclosed principal. So somebody is acting on behalf of principal, but he made the fact of agency to be known to the third party, but the name of the principal is acting upon is not identified. Should there be liability, the principal will be liable only if the person acts within his authority and control. Else, the agent will be liable. Now, undisclosed principal. This one is entirely different. You did not talk about the name of your principal. neither do you disclose the fact of agency, then the agent will be liable. The agent will be liable. However, the third party could also sue the principal if he later identifies that there's a principal. Now, undisclosed principal, in a situation where the agent conceals both the identity and the fact that he is acting for somebody, the third party is at liberty to enforce the contract against the agent or the principal where he discovers the principal exists. At this point, let me make the floor open for questions before we go into termination of agency. If you have questions for me, feel free to unmute your speaker and ask questions. Thank you. Adekunle Onifade, Olufunke, please, any question?
No question yet, please.
Okay, from you. What about from Adekunle? Do you have any question? Okay, brilliant. So thank you, Olufunke, for that response. Termination of agency contract. What do you mean by termination of agency contract? It simply means bringing an agency contract to an end. Termination of agency contract means agency contract that have been created earlier, we want to bring it to an end. So there are two ways to do that: by express act of the parties or by operation of the law. Now, by express act of the party, it's self-explanatory. That is, by mutual agreement of both parties. The parties agree that, okay, at so date, we are going to bring this agency relationship to an end. By so conduct, if it happens, the agency contract will come to an end. So by act of the party simply explain that agency transaction is terminated based on the mutual agreement of the parties involved. Now, by operation of the law, there are other ways with which agency contract can be brought to an end other than by act of the parties involved. So I will advise you, for exam purposes, just list them one after the other. You don't need to break it down into two layers. List them one after the other, because examiner will ask you, list 5 ways with which agency relationship can be terminated. So you don't need to be building it for them. Just list it. I mentioned that we have, or we can categorize them into 2 ways. One, by act of the party, down based on mutual agreement of the parties involved, by operation of the law. So by operation of the law could mean that what we can read into it that could cause termination, or by some conduct that could make the agency transaction to come to an end, or by the position under the law that could automatically make an agency contract to be invalid. The first one, through death of either party. If the agent dies or the principal dies, automatically agency agreement will come to an end. Where either party becomes insane, whether the principal got mad or the agent went mad, if anything happens to their psychological mind, automatically agency contract will be brought to an end. Where either of the parties becoming bankrupt, automatically agency contract will come to an end. By frustration. In law, when a contract is said to be terminated by frustration, we mean the action that brings about the termination of that contract is independent of the 2 parties. None of the 2 parties contributed to the existence of that act. A very good example is erosion could make a contract to automatically come to an end. So where there is a land erosion, for instance, and you want to sell a land, and we go there and we see that that land is not in good shape again, then automatically you cannot buy that land. So by default, that land cannot be sold. Again, because it's not in good shape. That's a very good example of what? Frustration. Natural disaster could also follow that frustration. Earthquake, volcano, etc. could also follow that frustration. So all these are independent of the parties involved. If the subject matter of the agency is found to be illegal ab initio, so what we are saying is that this reason why we came into that agency contract is not valid, is illegal. Automatically, agency agreement will come to an end. Where the subject matter no longer exists, automatically, agency agreement will come to an end by expiration or expiration of time. Here, say the agreement is like 10 years agency contract, and 10 years has elapsed or has expired. What happened? The agent's transaction will come to an end. Subsequent illegality of either transaction or of the status or capacity of either party. So if the capacity of the principal is subsequently questioned, if the capacity of the agent is subsequently questioned in law or by operation of the law, agency transaction will be terminated. That marks the end of our agency class. So we have a couple of questions to look at. Before we look at all these case study questions, there are ICAN tested exam questions. Let me open the floor again for question and answer. Thank you. The floor is open for question. Any question for my lectures? Is there anything you need clarification on so I can explain to you? Because this case study part, you'll be the one to do it yourself. Mine is just to guide you. So your understanding is what will help you to answer all these questions. Thank you. Adekunle Onifade, Olufunke. Let's put forward our question. I need that to be able to give you response to these case study questions. Okay.
Hello.
Hello.
Okay. I want to paint a scenario. I'm
Okay,
just thinking.
please do.
Okay. Like maybe there's a Hamming officer, an Oga
Okay.
one. So he has one of his subordinates. Maybe someone maybe someone was owing him money, and he has one
Okay.
of the subordinates to go after the person to go and collect the money. But in the
Okay.
process, while the subordinate was trying to get the money, he started he couldn't get the money on time, so he started torturing the guy. Now, if in the process the guy now died, between them, who will be liable? Is it the Oga that sent him, or the subordinate?
Okay. Fantastic. Is that your question, sir?
That's my question. If it
So
happens in such a way.
yeah. So you see, this question is a question that can be answered from many angles. I
Okay.
could see that the fundamental human right of the other guy have been entrenched. So that is the right to personal dignity. Is not supposed to be, they are not supposed to torture him except in a rare case. And in this case, it's not part of the condition. That's number one.
Okay.
Number two, to quickly give you a response, the superior person will be liable. And also the other army that tortured that guy to death will also have his own cake of the punishment. We can also take it advanced that the army as an institution can be called to question. There is a rule as to situation where army officers can go out to run after civilians to collect debt, except if that person is not doing this action under the canopy of being an army officer. Then the superior will be liable, and the agent in this case will also get his own portion of the punishment. But where the both parties, both of them, I mean the junior officer and the senior officer, are hiding under the canopy of army, I mean army as an institute, then we can actually sue army as an institute in this case. So when we sue army as an institute in this case, then these two guys will be identified and they will be punished accordingly. A very good example is that Lekki massacre. If you notice what happened, those people that are shooting are not the ones that they call to action, right?
Yes.
It is the army as an institution.
An institution, yes.
Yeah, let's forget the lies that happens. Someone who's saying is not aware. The army said it's based on instruction, but the army was pointed at, right?
Yeah.
So let's assume the case go in the right manner. So let's assume the army was found guilty of that offense. Then the army will now produce those people that went there to act above the authority given to them. That's the right manner to have carried the process out. So I hope I've been able to answer your real question.
Yes, yes, yes.
Fantastic. So you won't be surprised if this kind of question come in an exam. So I will teach you how to answer case study questions, there's no doubt. But at the same time, you also need to use your own church mind. I mean, your own wisdom. Because if not, you might get it wrong. Sometimes you will need your normal thinking to help you. Sometimes you need to follow strictly the law. So that is it. Any other question, please? Any other question?
Let's go on.
None at the moment. So it means all that have been discussed so far, you understand it, right? So if you do understand it, can you see my screen very clearly?
Yes, I can see it.
So let's together discuss the legal position on question number 1. What's your own view to this question? Thank you. It's going to be an interactive session, I said earlier. So answering questions will be very, very interactive. So I will not give answer from anyone. Okay, none from me, no question from me, sir. Okay, good. So now let's discuss. Let's discuss what we have here. Tumishi, let's discuss question number 1. I will answer question number 2 for you because during the course of my lecture, I didn't mention anything concerning question number 2. But for question number 1, this is discussed.
I think I'm coming. I think the station manager acted in good faith. Since he made several efforts to contact Hassan and for the goods not to perish.
Okay. Okay. Olufunke, okay, good. Go ahead. Okay, I'll thank you, Mr. Uyomi. Let's hear from Olufunke. Let's hear our view on this. Thank you.
Okay, thank you, facilitator. Thank you, Mr. My take on this is, if we read the question critically, the B part of it said, before going on holiday, Hassan left his contact address and telephone number where he can be reached, right? And from the look of the question from the beginning, there is no place that states that station manager tried to contact Hassan. He only said after several attempts to deliver the goods, which means he actually acted as an agent, but it was not expressly written that he tried to contact him. So I am feeling he cannot be called agent in that area. The legal position is that he acted truly, but he is not supposed to. He should have made attempt to contact him, to call him first.
Thank you, Madam Olufunke. That's a good opinion. So, Mr. Oriyomi, is it Mr. Oriyomi, the first part that spoke? Hello? Yeah, Mr. Adekule, yeah. Adekule.
Yes, it's Adekule.
So you have your opinion is different from Olufunke's opinion, right?
Yes.
Okay, good. Now let's strike balance. The first thing first, we can identify this to be agency by necessity, right?
Okay.
Do we both identify that as agency by necessity?
Yes. Yes.
Fantastic.
Yes.
That is how to answer a case study question.
Okay.
It is agency by necessity. Now, Mr. Uyomi, Adekule.
Yeah.
Yes, honestly, you tried, but imagine scoring 50 over 100. You pass. I can't pass my 50. So, imagine scoring the 75 over 100. Did you also pass?
I think I'm loving this.
But the point is, at the end of the day, I will celebrate both of you, right? I know many of you just want 50 and leave ICAN behind. So I will give it to Olufunke. She actually got the answer correct. There is a clause, and that is what makes the third, I think the first one condition not to have been met. So what is that? If you read it very well, everything sounds sweet. And you even open a separate account, yes, that makes him to act in good faith, right? Now, if he did not sell that product, honestly, that product will get spoiled, right? That is what makes his imminent commercial situation, emergency. it's a perishable goods, right? But was it impossible to contact the owner? The answer is no. Look at the clause. Before going on holiday, Hassan left his contact address and telephone number where he can be reached with the station master. It is this clause that make your opinion to be wrong, Mr. Adekunle. So your identification is very correct. Agency by necessity. Your point that he acted in good faith is also sweet. Are you there?
Yeah, me.
Your point that the situation is emergent is also correct, but you did not identify that it is impossible and impracticable to reach the principal. In this case, it is possible to reach him now, right? Because he left his what? His telephone number with the station master. You don't see why people fail ICAN. You might feel oh man, I've written the best thing, I wrote the best thing, then why did ICAN fail me? They failed you because you didn't consider this part. So it's possible that your first two identification might not give you less than 45. You see the difference now.
Yes.
Now, let us assume Olufunke did not even identify it very well. But look at our conclusion. Our conclusion makes it beautiful, right? Our conclusion alone can give her, let's say 30 plus 15. No, let's say 30 plus the first 20 she got. That's about 50 marks to pass. So ICAN can be so corny at times. So we just need to be careful while we are reading case study question. So I was saying it earlier, some case study question, you need your own knowledge to pass it. But many case study questions for law, you need to understand the principle. Without the principle, you might fail. So now, what's our position? The legality here is that in as much that, sorry. I'm coming. So in as much that the station master have acted in good faith, in as much that the situation is of commercial eminence, but it is possible for the station master to reach Hassan through his telephone address or contact address, but he failed to do so. Hence, no valid agency of necessity is created. Do you get it right? Does that make sense to us? Hello, class?
Yes, sir.
That makes sense to us, right? Good. Mr. Adekunle, that makes sense to you, right? I want to believe yes. I want to believe yes. So that's one thing you should always be careful of while you are attempting ICAN question. You need to read it. If possible, underline those. That's how I do exam. If you see my question paper like this, you will think I've written some expo inside of it, because that is the only savior I have. I will underline core points, key points. It will guide me on how to answer the question. Now, as a general rule in law of agency, an agent cannot delegate his authority. Yes or no? The answer is yes. But there is a maxim that we call delegatus non potest delegate. What does that mean? It means an agent cannot delegate his what? Authority. However, there are situations where an agent can delegate. There are what? Situations where an agent can delegate. Now, your next question will now be, if an agent delegates with the consequence action, let's say liabilities now, who will bond the liability? Is it the agent that delegates it or the principal? That is outside our scope of study here. When we get to case study, you might see something around that. But let's just answer this in a plain form. let me make this open to us. Can you identify circumstances under which an agent can delegate his authority? Now, let me help you with two. And don't tell me that that is the two you want to mention. Number one, where the custom of the law permits so. Where the custom or law permits to. So there are instances where the law allows you to delegate. For instance, there are some custom of trade that allows you to delegate. That's number one. Number two, where the agent lacks technical competence. Yes, they might give you a particular action to cover, and you discover that if you do it, you won't do it successfully. So you can actually call somebody on board to come and do it, while you take responsibility of the action. I've answered two. Oh yeah. Your view. Here we can use our own view, while I will tell you whether it's correct or not. Okay, let me help you with one more so that you can take one from yourself. So where the agent is ill, maybe for health purpose, the agent is not okay, and that assignment has to be delivered. On that ground, the agent can delegate. Number one, where the law or custom of trade permits. Number two, where the agent lacks technical competence. Number three, where the agent have health issues. During the time of illness, he can delegate. Olufunke, give me one. Adekunle, give me another.
Okay, sir. I don't know if this is correct, but since you said we should use our church mind, what if the principal is not available, not as a result of ill health, but not available? For instance, I am an agent, okay, I'm a principal and I am outside the country and there is a delivery I must do and it has to be done that day in Nigeria. And I think I could delegate that. How about that, sir? Just thinking aloud.
I think your view is respected. So, but I think there's a confusion. Do you mean the agent here? Because
Yes,
you mentioned principal.
When the person, is under which can we, the main agent, the person who is given the assignment, is not available within
Okay, correct. No. I get your point, but because of our audience, you mentioned principal. I know that's a mistake.
No, I mean the main agent now delegating to a sub-agent, if there is anything like that.
Yes, you are correct. But let me help you to rephrase it.
Thank you, sir.
So in this situation, unavailability of the agent to carry out the assignment due to unforeseen or contingent action. But in this case, he must have given prior information or given prior notice to the principal to do so. So a very good example is, I explained this yesterday. I'm to represent my company for something yesterday. So somebody is to represent another institution, government institution, put to say. And that meeting is very important. Even if I did not attend that meeting, I may lose my job. Now, the woman that's supposed to anchor that meeting from the government point of view gave me till 11 to be in her office. And you know Lagos traffic. I think a former head of state was buried yesterday, right? So there was traffic everywhere on the island. Do you know when I got there? I got there around past 1 due to traffic. Who is to be blamed? Will I tell my organization that it's because of traffic? No. So what did I do? When it's almost 11, I had to call the woman. I appealed to her, and I was like, can you please, since you said you won't be available anything after 11, can you reach out to the head of so unit that you want to delegate your assignment to somebody, so that anytime I come, that person will attend to me? There was a lot of forth and back in our discussion, but at the end of the day, she delegated it. But look at the process. she did not just delegate it because she's going now, because of her appointment somewhere. She had to inform the superior officer to do so. So the superior officer in this case is who? Is the principal. So in a situation where the principal did not agree to it, my sister, if you did Canada, you go to come Nigeria, come pick them. That is clear. But exam purpose, it will fly. Honestly, it will fly. It will fly. Oh yeah, your view. Don't say I've said your view. Say another one. Oh yeah, go ahead. Mr. Dekule, can we hear your view? We have one more to go. Olufunke, do you want to try again? Do you want to try one more? Hello, Olufunke, do you want to try one more? We still need one more answer to make it 5. I've given 3. You've given 1. Our Dekule is supposed to give you the last one, but I guess he's having issue with his speaker. I can't hear him. Do you want to help out? Just give us one more, and I can confirm it for you. Still thinking. Okay, keep thinking. Oh. Thank you. Okay. Let me help. Okay, or do you want to say something now? Okay. Now, an agent can also delegate authority given to him by the principal where there is conflict of interest. For instance, if the agent carrying out that action will affect his judgment, the agent can delegate. Yes, under the law, it is permitted. For conflict of interest purpose, if the agent carrying out the action will affect his judgment, the agent can delegate. So, thank you very much. That marks the end of our session for today. We've been able to fully discuss the topic theory of agency or agency law, as the case may be. This topic is highly examinable. If you go check the past question, almost every year, examiner would love to ask questions on theory of agency. Thank you very much for your audience. I look forward to see you again next week, Saturday. Before bringing this class finally to an end, I would love to have your comments I would love to have your feedback. And if it's a question, I would love to have it. Olufunke, over to you. Thank you.
I want to say thank you, sir. It's been an exciting and engaging class, even though I came in very late. I had some network challenges at the beginning, but thank you so much, Mr. Afiz Adepinkwe. We hope and pray that God will help us to pass. It's my first attempt. I don't have accounting background, and I'm hoping I'll be able to do well. Thank you so much. Please.
Yeah, you will. That's why I decided not to use too much of legal terms. We make the session look more of a friendly one, because many people say, law is hard, law is hard. I understand. Yes, so that's why I made it so simple, as if it's normal theory that you see everywhere. I wish you all the best, and I want you to remain focused and get an innate motivation, meaning motivate yourself inwardly, and trust me, your first attempt will be the final attempt for this foundation stage. Thank you for your audience, and God bless you all.
Amen.
Good day for now. Bye.